Criminal Law 1, Indian Penal Code, Theories and Kinds of Punishment revised is the topic for discussion today. Dear student friends, today I wish to take up from Indian Penal Code, that is Criminal Law 1, one of the most important topics, theories and kinds of punishment. This topic is common in three subjects. This topic appears in Indian Penal Code, and it also appears in jurisprudence or legal theory subject. One of the chapters is theories and kinds of punishment. In criminology, penology, and victimology, or criminology and criminal administration, in that subject also, this topic is one of the chapters. So this subject, this chapter, theories and kinds of punishment, will be useful for you in three subjects, namely Indian Penal Code, jurisprudence, and criminology, penology, and victimology, or criminal law, criminology, and criminal administration. Three subjects. In this lecture, I want to enlighten you in brief about three bills relating to criminal justice in India presented by Honorable Home Minister Amit Shah ji on 11th August 2023. Then I proceed to uh, meaning and objects of punishment, and theories of punishment, and various kinds of punishments I will take up in this lecture. Why I wish to enlighten you in brief about these three criminal law, three bills relating to criminal justice, that students may come across the doubt that when once these three bills are passed into law, the IPC, CRPC, and evidence will be no more useful. They are replaced by new enactments. As what that type of doubt you may get, and how to clarify that doubt. That is why I want to explain you in brief about these three bills. So, about in this lecture, I will take up these three bills presented by Amit Shah ji in Lok Sabha on 11th August 2023, meaning and objects of punishment, theories of punishment, and various kinds of punishment I'd like to take up. Before going to take up, dear friends, let me take just half minute to pray God. Pay homage to my reverend parents, late Regaprab, late Srimati Kantaratnam, and my wife, Mrs. Balivada Rega Tirumala Gauri, my academic associate. I express my deep sense of gratitude to my godfathers who are instrumental for what I am now. It's my duty to express my heartfelt thanks and gratitude to the publishers of research papers and articles in internet. And finally, it is my duty to express my irredeemable indebtedness to my students' friends who are instrumental for what I am now. Now, this on 11th August 2023, recently, Honorable Home Minister Amit Shah ji presented three bills on criminal justice. Three bills on criminal justice, namely Bharatiya Nyaya Sanhita 2023 bill to replace Indian Penal Code 1860. Secondly, Bharatiya Nagarik Suraksha Sanhita Bill 2023 to replace the Code of Criminal Procedure 1973. And third, Bharatiya Shaksha Bill 2023 in order to replace the Indian Evidence Act 1872. So these three bills envisages these bills are these three bills envisage replacement of replacement of three bills, three enactments, most important enactments relating to the administration of criminal justice in India. These three enactments are most important. These three are the three pillars of the administration of criminal justice in India. In addition to this, the fourth important pillar is the Code of Civil Procedure, Civil Procedure 1908 relates to administration of civil justice. These three enactments, IPC, CRPC, relate to criminal justice, CPC relate to civil justice, evidence relates to both civil justice and criminal justice. Criminal justice. So act whenever any criminal law amendment is made, that criminal law amendment act, so far 78 criminal law amendment acts were passed. Whenever any criminal law amendment act is passed, it will bring about certain changes not only in criminal laws, that is IPC and CRPC, but also in the law of evidence. Example 111A, 113A, 114A, and all these things I enlightened you in detail in while teaching law of evidence. So the Indian Penal Code is a substantive law of crimes that it defines various offences and prescribes punishments. The Code of Criminal Procedure is the procedural law. That means it lays down the procedure. It lays down the procedure for administration of criminal justice, while the law of evidence provides it is procedural law. IPC is substantive law, CRPC is procedural law, but evidence is said to be procedural law, but some others take it, it is law of pleadings. It is law of pleadings. So as per the provisions enshrined in law evidence, the pleadings are placed before, the pleadings are made in the courts of law. So this is so far as CPC is concerned, it relates to, it is adjective law, where not only it is a procedural law as well as substantive law. So the sections area, all the sections of CPC deal with substantive aspect, and the corresponding orders and rules deal with procedural aspect. So IPC is substantive law, CRPC is procedural law, and evidence is procedural law, and also is law of pleadings. Finally, this Civil Procedure Code 19, the Code of Civil Procedure 1908, it contains two parts. The sections part, body, formed by which are to be amended by the central legislature, that is parliament only. The other part is orders containing rules. They can be made and amended by the respective state legislatures. So that is why CVC is both substantive and procedural law. So these IPC, CRPC, evidence are the three pillars of administration of criminal justice, whereas CPC, if we add CPC, IPC, CRPC, evidence and civil procedure code are the four pillars of the administration of justice, and they are designed in consonance with the provisions of the Constitution of our India. So as per the guidelines of Indian Constitution, these four enactments are designed. So that is why if these four pillars are to be constructed as per the plan furnished in plan furnished in Indian Constitution. So these are the three bills, most important bills presented in the Lok Sabha. In addition, in 2003, as per Google Net information, 34 bills were presented in Lok Sabha. In this, totally there are about 216 bills. 216 bills are pending before the houses for passing into laws. So, in addition to these three bills and 31 more bills, totally 34 bills were presented during the year 2023, and some other bills, total about 216 as per net, are pending before bills are pending to be passed into law. So we have, as per our previous experience, when a law is replaced and a new law is made. Suppose Companies Act 1956 was there, it was passed in the year 1956 and it was recodified in the year 2013. And immediately when a law is passed by Lok Sabha, Rajya Sabha and assented by President of India, it will be written to the Ministry of Home Affairs and for gazette notification. The gazette notification sometimes may be delayed. Even after the assent of the President of India, the bill may be passed into law. His gazette notification may be take place years together, 2-3 years, 4 years, 5 years, like that. The Consumer Protection Act, which was passed in the year the Consumer Protection Act, which was actually passed in the year July 8. Actually the Consumer Protection Act is 1886. It was recodified and the bill was presented in Lok Sabha on July 8, 2019 and it was passed into law in the July 2000, July 14, I think, July 2022. So after 3 years, the act was passed into law. We have labor legislations. We have labor legislation. The labor and industrial laws, you study in labor and industrial laws. So there are about 29 labor legislations in India, 28 central labor legislations, and the 29 central labor laws was consolidated into 14 law codes. 14 law codes. That is so four labor codes. There, in subject labor and industrial laws, there are so many acts. We studied so many acts, namely Industrial Disputes Act, Workmen Compensation Act, Trade Unions Act, Employee Standing Actors Act, Minimum Wages Act, Payment of Wages Act, so many enactments are there. So like that, Employee State Insurance Act, like this. So like that, there are 29 central labor laws, labor legislation. All the 29 labor legislation have been consolidated into 4 labor codes. Act or code, they are identical, synonymous. They are almost identical, just like teacher, lecturer, professor. So these 4 codes were presented in Lok Sabha. Lok Sabha in 2019 and 20. They are the code on wages 2019, the industrial relations code 2020, the occupational safety, health and working conditions code 2020, the code on social security 2020. All the labor legislations, progressive, all the welfare legislation relating to the workmen employed in industrial establishment, these 29 legislations were consolidated into 4 labor codes as detailed below, namely the Code on Wages 2019, the Industrial Relations Code 2020, the Occupational Safety, Health and Working Conditions Code 2020, fourth one is Code on Social Security 2020. These codes were presented in Lok Sabha, but they remain pending. They are in pending. They have not yet been passed into law. However, we people from all the concerned are in confusion whether to follow this or law, when these laws would be passed into law. So many others who wanted to revise books as per this stopped in the middle. I too attempted to revise labor laws. Having learned about these codes, I stopped revising my subject on labor law. So, when these bills presented in Lok Sabha may be passed into law, we cannot say it is the authorities to decide depending upon the importance and need and necessity. The certain bills would be passed into law in short time. However, certain bills would be passed into law very late, because when well a bill is to be passed into law as an enactment, there are so many, they refer these bills before passing into law to so many subject experts and intellectuals, that is state legislatures, MLAs, MPs, like that. So like accordingly our these criminal law courts, namely Bharatiya Nyaya Sanhita Bill 2020, Bharatiya Nagarika Suraksha Sahita Sanhita Bill 2023, Bharatiya Saksha Bill 2023. These bills were referred to states, union territories, Supreme Court, high courts, judicial experts, judicial academies, national law schools, MLAs, MPs, and other public. But 18 states out of 28 states, they were referred. They gave their opinions, and 6 union territories out of 8 gave their opinion. Supreme Court, 16 high courts, judicial academies, 5 judicial academies, 22 national law schools, 142 MPs, 142 MPs, 270 MLAs have given their opinions were taken before passing them into law. All these things are there. When once the opinions are collected from various sources, there will be conflict of opinions, quite obvious, and consolidating all these opinions, any bill would be passed into law. Any would be passed into law. So as per these bills, these three bills, three RPC, in CRPC, that is Bharatiya Nagarika Suraksha Sanhita Bill, and there were 484 sections. The 484 sections are proposed to be 533 sections. 160 sections are changed, 9 sections are added, and one section has been deleted, repealed. So IPC, Bharatiya Nyaya Sanhita Bill, that is originally IPC contained 511 sections divided into 23 chapters. After 78 Amendment Acts, the number of sections rose to 576 and divided into 26 chapters, including 5A, 9A, and 20A. And then in this particular bill, 175 sections have been changed, that is revised, 8 sections added, 22 sections are deleted. So far as evidence is concerned, originally it contained 100, now this Evidence Act contains 167 sections. The 67 sections is made into 170 section, that is 3 more, earlier it was 167, now it is 170, and 23 sections have been revised or changed. 1 section added, 5 section deleted, like this. So many changes have been made. All these changes are inevitable and incompatible, because the most of our legislations were passed during British regime, British rule, that is in 1868. The earliest enactment passed was Indian Penal Code 1860, Indian Evidence Act 1872, Transfer of Properties Act 1882, like that. These legislations are more than 100 years old. They taking into consideration the socio-economic conditions at the time, these acts were designed and passed. But today, in view of so many changes, drastic changes in our living condition, social, economic, political, cultural, and all, change of these laws is inevitable and incompatible, keeping in mind all the need and necessity to recodify various branches of law. Honorable Prime Minister of India, Narendra Modi ji, said in 2019, our legislations are more than 100 years old, and they have to be revised. But this idea is very good. This idea is very good, but putting this in operation is not an easy job. It is a very complicated job. For instance, in 2013, 2023, 34 bills, including these three bills, have been presented. Earlier, so many bills are pending, and more than 40. There are about 40. There are more than 40 constitutional amendment bills are pending. So for this, it might not be the government is busy with the various assignments, welfare schemes, and all, and because of the conditions beyond the control, the government may not be in a position to pass all the laws so quickly. They have to think and act before passing them into law, and there are so many constraints, technical and otherwise. So that is the reason why the delay is made. So keeping the dear friend, don't worry. For instance, our Consumer Protection Act was originally passed in the year 1986. The Consumer Protection Act was originally passed in the year 1986, and it was passed into act. That is, it was passed into act in 2022. Originally, the Consumer Protection Bill was presented in Lok Sabha on July 8th, 2019, but it was passed into act in the year 2022. It came into force sometime in July 14, 2024. So after presenting the bill, it took 3 years for consumer. So similarly, Motor Vehicles Amendment Bill was passed in July. In July, Motor Vehicles Amendment, it was passed in July, but it came into force on 1st September. 1st September, 2000, Motor Vehicle Amendment Act was present in Lok Sabha in July 2019, but it was passed into law on 1st September. Very shortly, Motor Vehicles Amendment Bill was passed. Subsequently, Motor Amendment Acts also came after this 2019. 2023, one Motor Vehicle Amendment Act is there. That act envisages destruction of vehicles which are more than 15 years old. So these in all vehicles, including the government vehicles, have to be destroyed after 15. So like this, dear children, please don't think that when a bill is passed, it will be passed very quickly. What we are studying is not useful. It will be in vain. Never think like that. Even if a law is codified, but some changes will be made as per the present socio-economic conditions. The old most of the area, most of the volume from old act will be will be incorporated in the new act. For example, Indian Companies Act 1956 there. When in Companies Act was passed into law, that Companies Act 1956 is recodified in the year 2013. So many provisions as it is reincorporated in the Companies Act. Some sections naturally deleted. So what was the provision in old Companies Act? It is repeated in the new Companies Act. What are the provisions in new old Motor Vehicles Act? Originally, Motor Vehicles Act was passed in the year 1939. Then it is revised in the year 1988. Again, it is revised in 2017. Like this, 2033 amendment acts are there. So many amendment acts are there. So like this. So the whole as a whole will not be changed, but the some whatever areas are to be changed. Some the section number may be changed. So many provisions which were with the section number of so many provisions is one in old act, and another act, the section number will be changed in new act. Certain sections are deleted sections. So that is why in so many enactments we are having CPC, CRPC evidence and all. There are so many amendment acts. That is the reason why we are adding A, B, C, D, E, F, G, H, section 375, 376 IPC. So many sections are added, and Evidence Act, so many sections are added, A, B, C, D, like this. So in order to delete the confusion
about the adding A, B, C, D, E, F to that. Some all the sections are overall consolidated. For example, some in a house is when I think article is there, time to time we will repair, and ultimately we have to demolish that building and construct new building like that. So the old acts, the amendments and the old rules will be clubbed and they are recodified. So whatever we studied in old, it will be completed in the new. Certain provisions and certain aspects are remain unchanged through for generations and hundreds, more than hundreds, decades and centuries. But certain provisions remain unchanged. So far as this like that, don't think that any topic is taught that the topic will be no more. It will be useful, but certain points or certain area is changed. Whole area will not be changed. For this purpose only, in order to enlighten you, I have added this thing, and let us hope these three are most important acts. I hope the government will not be that much hurry, because all political parties are in tension regarding next year elections. There are so many bills. I told you just now, 216 bills are in pending in Lok Sabha as on today. Only in 2023, 34 bills are presented in Lok Sabha, including these three bills. So like this. So accordingly, the CPC also bill also has to be presented. Anyway, overall speaking, all the bills which were present, which are in practice, which were passed in British regime, have to be changed, have to be revised.
Even recently, motor vehicles very frequently amendments are coming, and there are demands from various sectors, stockholders, stakeholders, to bring about changes in all these things. Now coming to the a point. Now, sorry, I have taken a lot of time. This is for your information only, to enlighten you. Don't think that I am speaking hammering. Now we have to come to the subject, theories and kinds of punishment. So any activity is there, any performance is there, it is to be done in consonance with particular principle or particular rule or particular theory. So we know some certain if the density of if the density of particular object is more than water, it is drowned. It is less, it will be floating. It is equal, it will be equal, it would swing in the waters like this, the Archimedes principle. So like that, basing on Archimedes principle, so many things were invented. So like this, when a particular activity or performance is done, it is to be, the basis will be there. Such basis is called theories. Why punishment? What is punishment? What is the object of punishment? What are the theories of punishment? In the sense, why punishment should be given? Why punishment should be given? We have to know. Punishment is a process. Punishment is a process by which some pain or injury or loss or damage is inflicted to an individual, an individual found guilty of an offense. If injury or pain is inflicted, if injury or pain can be inflicted to human body, that is person, and injury, loss or damage can be imposed to his property, movable or immovable. So when once a pain or injury is inflicted to an individual, that who is found guilty of a crime or an offense, that is punishment. So similarly, if a loss or damage is imposed to a person's property, movable or immovable or intangible property like intellectual property, that is called punishment. So the punishment means, punishment is a process by which the state or state sovereign, as per law, inflicts pain or injury to person, or loss or damage to the property, movable or immovable, that is called punishment. This punishment, why punishment is given? What are the objects? There are three objects for punishment. The first object is when a person committed an offense, if he is not given any punishment, he is freed in the society, he cares no pin and he will commit the same offense again and again. In order to prevent him, in order to abstain him from not committing the same offense again and again, punishment is inflicted. For example, you take the case in our childhood when we go to school, if the homework is not done, teacher used to beat the child. So then, when once for not doing the homework, if the child is beaten, next time he will come prepared to school with completing the homework. That is one reason. Secondly, the first object is not to repeat the offense in future to the criminal or offender. Second object is when a punishment is given to somebody, the surrounding people will think, oh, he has committed that offense. That is why he is punished that. So let us not do such offense. So it will create fear among the people around. So seeing this particular punishment, the surrounding people, that is the members of the public and other people do not, so and so some A committed an offense, he is punished like that. So B, C, D, E, F and all people say that also if we commit this offense, we too will be punished like A. So let us not commit that particular offense. So it is a warning to the surrounding people not to do. That is second object. Third object is the fundamental responsibility, duty and responsibility of state sovereign government is to maintain law and order, ensure social security, and the fundamental duty of a state is to provide security, the social security, law and order, but for which the people will not be able to live safely, happily, and pleasantly in their respective homes. So it is the duty of the state to protect the people from the threats of criminals, threats of thefts, robberies, and other crimes. So that is the third object. So for these three objects, the punishment is envisaged. Now there are, why these punishment? What is the basis? What is the origin for emergence of this punishment? And there are some theories. There are four theories in most of the book, and one more theory is there in some books. That is that is expiatory theory. First theory is deterrent theory. Second theory is retributive theory. Third theory is preventive theory. Fourth theory is reformative, and fifth one is expiatory theory. Deterrent theory, retributive theory, preventive theory, reformative theory, and expiatory theory. Now, first one is deterrent theory. This deterrent theory is identical to the punishment of qisas. Deterrent theory is corresponding to the objects of this punishment. So, deterrent theory, the purpose of according to deterrent theory, when once a person commits a crime, he is called offender or convicted person. So that person is given punishment. So if he is given punishment, he will not do the same offense in future. Secondly, it becomes a warning to the surrounding people. So this is the purpose of, this is what deterrent theory tells you. Deterrent theory means to deter an offender or a criminal not to do the similar, not to commit the same offense in future. If punishment is given, he will not commit the same offense in future. If the punishment if the punishment is given, he will not commit the same offense. If he is not given any punishment, he is freed freely, he will commit the same offenses again and again. That is to correct the criminal or offender or convicted person. Secondly, it gives warning. It educates the surrounding people. It gives warning to surrounding people in the society. Don't, so if you don't do like this, if you do like that, you also will be punished. That is warning. This is what deterrent theory tells. Second one is retributive theory. retributive theory speaks about to give, to retribute, to return what is received. So this retributive theory is identical to one of the punishments during one of the punishment prior to Indian Penal Code, wherein Mohammedan criminal law was in practice. It is equal to qisas. Head for head, eye for eye, teeth for teeth. Here, according to this retributive theory, if A kills B, B's legal hair can kill A. A plucks out the eye of B, and B himself or his near or he dear legal hair can pluck out the ear of A. So A breaks the head of B. B also can break the head of A, or his near or he dear can break the head of A. Like this, tit for tat. Like this, eye for eye, teeth for teeth. If A disfigures B, B or is near or dear legal hair can disfigure A. So this is what this deterrent theory. This theory is subjected to criticism that it is heinous and barbarous. It appears to be offense means offense must be an offense against the society or public at large. It must not be an offense against an individual. So it is criticized that retributive theory is not an offense against society or public. It is an offense against another human being, another person. So and that way it is criticized. Third one is preventive theory. Preventive theory means the criminal or offender is confined somewhere so as to prevent him from doing the same offense. If an offender, once an offense is committed by a criminal or an offender, if he is allowed freely in the society, again and again he will commit the same offense. He will repeat the offenses. If he is confined, if he is put in four walls without going anywhere, if his personal liberty is curtailed, he won't be able to go out and he won't be able to do any similar crime. That is what is called preventive theory. The preventive theory says that when once a criminal committed a crime, thereafter he must be prevented from committing the same crime by confining him, by keeping him in a closed room. From this, the process of imprisonment or custody under police or jail has come into existence. So that is what is called preventive theory. So this preventive theory also is subjected to some criticism, but confining someone, we are making him idle, and we are making him idle without if we keep a person and feed them, it is expenditure to the government, and by keeping a person, he cannot be corrected. He will remain as a criminal. Even after release also, he may commit the same thing. That type of view was there. Instead of keeping him, better reform him, make use of his service. That proposal was made. That proposal or the initiative was fructified in the fourth theory, that is reformative theory. Today, this reformative theory is in practice in all jails. So almost all in taluk headquarters or mandal headquarters, small jails are there. In district headquarters and other places, central jails are there. Now today central jails are in hundreds of acres, thousands of acres, because it is like a small town. It is like a small village or town. During the whole day, all the criminals are freed within the jail campus. They can move like how people move in a town or village, and they are assigned with so many jobs. The convicts who are given rigorous imprisonment are required to do some labor, digging earth, doing so many jobs. There are, so here, instead of leaving the instead of keeping the criminals in jails idle, let us give them an opportunity to work something and earn something. That is why there are so many activities are provided to the prisoners are provided an opportunity to continue their education, and they are allowed to write examination also. And so many these whatever service they have rendered, they are paid some remuneration, that is called prison labor. If any certain acts are done for the jail, for gardening, or uh, these prisoners also are asked to do cultivation also. Kerala is best example for best functioning of open air prisons. Now there are open air prisons also. In open air prisons, certain the cultivation and other activities are taken place, and live wires will be erected around the open air prison so that no one can escape. If anyone happen to escape, if he touches the live wire, he will die on the spot. That is why even jail walls also, compound walls also are very high, very high. Nobody will be able to jump over it. So this is the openness reformative theory tells that when once these convicts are kept in prison, their services are to be utilized. If their behavior is good, if their conduct is good, they are given some bonus marks and bonus days, so that they will be able to release it early. According to section 53 of the Indian Penal Code, the state government is provided state government is conferred power to reduce the sentence depending upon the good behavior. This power of state government to reduce the sentence has been some amendment is made. So when once the state government wants to reduce the sentence of any particular convict, it should be done with the consent of the aggrieved party. With the consent of the aggrieved party. If the aggrieved party is deceased, the legal hearing is to be consented. Like this, the type of amendment is there in a proposed amendment act. So this is reformed. Next one, fifth one is expiatory theory. Expiatory theory depends upon in a few books this is there, and most of the books first four theories are there. Expiatory theory means the person who committed offense, the person who committed crime punishes himself. He feels very unhappy for having done. So knowingly, unknowingly, the culprit, the offender might have committed an offense knowingly or unknowingly, intentionally or unintentionally. For that, he suffers a lot. Sometimes he gives punishment to himself by jumping into river, by lighting fire, by pouring kerosene or petrol on body and lighting a matchstick, and these things. That is what is called expiatory theory. So this is what is called offense and punishment. So in one Telugu movie, one hero, that is National Naramu Shiksha in Telugu, Tollywood, that hero Krishna by driving hit three pedestrians. In that process, one pedestrian Balaya lost his eyes, and subsequently he came to know. And this so-called rich man, hailing from an aristocratic family, went to that home to rescue, and he served a lot like an ordinary man, and he strove hard to feed that family, and leaving all his riches at home. So he himself gave punishment for him, leaving wealthy royal family. He went to a small house to serve. This is an example for expiatory theory. So Krishna's punishment to himself in a movie Naramu Shiksha, in that Telugu movie. So these are the various theories of punishment. And the second phase is kinds of punishment. Indian Penal Code was 1860 was passed. Indian Penal Code was passed in 1860. It came into force from 1st January 1862. At the time also, Indian Penal Code, after passing, came into force after 2 years of its passing. It was passed in 1860, came into force from 1st January 1862. Like that, a punishment. Before Indian Penal Code came into force, the Mohammedan law was in Mohammedan criminal law is in force. Mohammedan criminal law was a territorial law. It was applicable to Hindus, Muslims, Christians, Parsis, Jews, all communities. Mohammedan criminal law was common to all, but whereas civil law is varies from community to community. Muslim personal law is as per Quran. Hindus personal law as per Shastras. So even today, Mohammedan personal law is different. Hindus personal law is different. Like that. So the personal law are different from community to community. Hindus, Muslims, Christians, Jews, etc. Like that, in those days, before Indian Penal Code, before 1860, Mohammedan criminal law is there. There are so many defects in Mohammedan criminal law with reference to punishments. There were, so far as there were 5 kinds of punishments in Mohammedan criminal law, namely Kisa, Diya, Hadd, Tajir, Siyasat. Kisa means head for head, eye for eye, as per our deterrent, as per our retributive theory. So A kills B's legal here will again kill A, like that. A breaks B's head, B or his near or dear will break A's heads. So A plucks out B's eye, and B himself or his near or dear or legal hair will pluck out the ear of A. So head for head, this punishment is called kisa. Kisa or Qisas, kisas is first type of punishment. Second one is diya. Diya means blood money. Blood money. In those days, according to Mohammedan criminal law, any crime can be committed. If the aggrieved, the offender could pay money to the aggrieved. A kills B, but B's legal here has an option to receive money, or B's legal here can kill A. If he wants to follow Kisas, B's legal here would have to kill A, or he would simply accept money, and any offense could be committed, and the offender could escape from liability by making payment to the aggrieved or his legal heir, or that is next kith or kin. That is kisa diya. Diya. Second diya is called blood money. Blood money. Third one is hadd. Hadd means fixed punishment. For certain offences in Mohammedan criminal law, fixed punishments are there. Today in Indian Penal Code, for every offence, minimum punishment is there, maximum punishment is there, fine also is there. Both punishment, that is imprisonment, and fine also are there. For every offence, there is a minimum and maximum is there. But for the section 303, minimum and maximum is not there. Already a person who is found guilty of murder and is sentenced to life imprisonment, and he is undergoing life imprisonment, again he committed murder, then the punishment will be only death sentence according to section 303. Either commits murder or attempt to commit murder, then his punishment will be death sentence. There is no any minimum or maximum. It violates article 21 and 14 of Indian Penal Code. It was challenged in a Mithuvas state of Punjab, and it was then accordingly section 303 was struck down, deleted from the Indian Penal Code because of that. So like this, there were in Mohammedan criminal law, the third kind of punishment was hadd. Hadd means fixed punishment. For example, for offense of zina means rape, only death sentence. For there is a law of evidence. 4 eyewitnesses should give evidence in the court to prove the offense of zina, which was very difficult. So that is there. And the regarding defects in Evidence Act also I will tell you. Hadd. Hadd means fixed punishment. If anybody commits theft or robbery, his hands and legs, hands may be amputated. updated, or like maybe whatever offense, the punishments were very brutal as far as the had. Had means fixed punishment. For offense of zina, only death sentence, no less or more. No, neither less nor more. Tajir, discretionary punishment. Whether to give more punishment or less punishment, the judges are given discretionary power. Discretionary power. This process gave room for corruption of the judges. When the corrupt judge received a bribe, he was awarding small punishment, and when he did not receive any bribe, he was giving more serious punishment. That is kisadiya had tajir. Last one is siyasat. Siyasat, the king against the complaint of the public punished the person. For example, there are some mischievous fellows in the public. They are creating a lot of nuisance to the public. If the public gives complaint to the king, so and so is creating a lot of trouble. We are not able to move freely. Is giving a lot of trouble. If the people give complaint to king, king had to punish that person. These are the kisadiya had tajir siyasat, or the kisadiya had tajir siyasat were five kinds of punishment. There were also defects in Mohammedan criminal law. There was a male domination was there, Muslim domination, Mohammedan domination was there at that time, because the evidence given by one Muslim was equal to evidence given by two Hindus. The evidence given by one man was equal to evidence given by two women. So one Muslim is equal to two Hindus, one woman to one man is equal to two women for a particular evidence. Suppose four Muslims have to be given. If it is Hindus, eight Hindus have to give evidence. If it is Hindu ladies, 16 Hindu ladies have to give evidence. That was the position. So one Muslim is equal to two Hindus, one male is equal to two females. For offense of zina, that is rape, direct witness or eyewitness should be given. Four eyewitnesses should give evidence in court to give punishment to the zina, rape. So it is for sexual offenses, it is not possible to produce eyewitnesses, because the sexual offenses, including zina, that is rape, take place within four walls, that is in a clandestine way, so that there won't be any opportunity to anybody to witness and give evidence. So that is the type of defects were there in Mohammedan criminal law. All these defects were overshadowed with the passing of the Indian Penal Code 1860. As this Indian Penal Code consolidated this punishment, this Indian Penal Code 1860, which came into force on 1st January 1662, contained originally 511 sections divided into 23 chapters. By subsequent amendments up to 78 Amendment Acts, the number of sections rose to 576 sections divided into 26 chapters, with the inclusion of Chapter 5A, Chapter 9A, and Chapter 20A for your information. So, theories and Mohammedan criminal law. Present, as per Indian Penal Code, what are the punishments as per Indian Penal Code? There are 6 punishments as per Indian Penal Code. There are 6 punishments as per Indian Penal Code. First one is death sentence or capital punishment. Second one is life imprisonment. Previously, this life imprisonment was called transportation of life. By Criminal Law Amendment Act, this 1955, this was changed as the transport of life was renamed as life imprisonment. First one is death penalty as capital punishment. Second one is life imprisonment. Third one is imprisonment, that is simple imprisonment and rigorous imprisonment, forfeiture of property, and fine. So, according to these there are 5 punishments. according to Indian Penal Code, under section 73 and 74 of Indian Penal Code, sixth punishment is there, that is solitary confinement. Solitary confinements mean those person who were given punishment under these five lines, and they may be kept in solitary confinement. This is additional provisions to the already convict who is undergoing imprisonment, and the term of solitary confinement should not be more than 3 months. Below 1 year offences, 1 month, and 6 months to 6 months to 1 year, 2 months, like this. These rules I will tell you later. Now coming to the death penalty or capital punishment. This is the capital punishment of death penalty is there in Indian Penal Code. It is the most serious means of punishment. In this process, the person is killed, is hanged, and till death. So this capital punishment is in practice in some countries. It is abolished in some countries. That is why there is a demand for abolition of capital punishment, because some experts say that speak in favor of capital punishment. They say that capital punishment should be continued. Some say that capital punishment must be abolished. Some countries abolished, but in India, capital punishment is there. Capital punishment is there. In Mrs. Gandhi assassination case, capital punishment is implemented. Rajiv Gandhi's assassination case, then Nirbhaya's case. Recently, these death sentences were implemented. What I executed, what I explained in previous classes. So capital punishment. So when coming to the point, there is a arguments for and against capital punishment, that the Supreme Court in Jagmohan Singh versus State of Uttar Pradesh, the Supreme Court said that death sentence is the Uttar Pradesh High Court said it is unconstitutional, but Supreme Court said that death penalty is not unconstitutional. It is constitutional, provided it is executed as per the procedure established by law. That is, no criminal shall be deprived of his life and personal liberty except according to procedure established by law, is what Article 21 tells us. In the beginning, it is expanded from time to time, is what I told you in Article 21 in Constitution Law 1. So coming to this, according to Jagmohan Singh versus State of Uttar Pradesh, Supreme Court said this death penalty is not unconstitutional. It is constitutional, provided it should be executed as per law, as per the procedure established by law. So Midhu versus State of Punjab, there is according to section 303 of Indian Penal Code, when a life imprisonment convict commits a crime again, commits murder or attempt to murder, he should be given only death sentence, no minimum or no maximum. For all the punishments, minimum and maximums are there, but this particular section, there is no minimum and maximum. Equality before law and equal protection of law is what Article 14 of Indian Constitution tells. Accordingly, this violates Article 14, and it deprives the life of a person, and violates Article 21. So that this in Midhu versus State of Punjab, this article, this section 303 was deleted. Similarly, Bachan Singh versus State of Punjab, the question of when death sentence can be given, what is the period, in this particular case, it is given to understand that the death sentence, the life imprisonment period was fixed at 12 years, but in mostly 14 years, 14 years imprisonment is there for life imprisonment, computed as 14 years. According to Article 433B Criminal Procedure Code and 55 IPC, the government is having the power to reduce all these things. And coming to the point, in Bachan Singh's versus State of Punjab, what happened was, the court gave some guidelines. What are the circumstances under which 20 years imprisonment can be given? So, in one case, Supreme Court said life imprisonment is 12 years. In some cases, the Supreme Court said life imprisonment is 14 years. But life imprisonment can be given 20 years. What are the circumstances? There are 50 instances wherein the Supreme Court, there are 50 instances wherein death sentence can be given. So when the death sentence must be given in rarest of the rare cases. For example, in decade, when a robbery takes place by 5 and above, it is called decade, and that decade results in death of anybody, causes death. That then the person who killed who is the guilty of murder and decade should be sentenced to death. Suppose if anybody gives false evidence, with that false evidence, an innocent is convicted to death, is sentenced to death, and death sentence is executed. Subsequently, it is made known that that person gave false evidence. Because of the false evidence, death sentence is given. So, death sentence is given in rarest of the rare cases. What are the circumstances under which death sentence is to be given? What are the circumstances under which the this 20 years imprisonment is to be given, is to be decided by the court, taking into consideration circumstances of the case. When once the capital sentence is awarded, and this is to be, it is to be ratified by the high court or respective high court. The district session judge is competent to give death sentence, and it is to be ratified by the respective high court. This is capital punishment. Second one is life imprisonment. Previously this was called transportation of life, transportation to life. The life imprisonment is naturally meaning is to so long as the convict is alive, he should spend his in jail, and he should die in jail. But however, it is said that life imprisonment was decided as 12 years in one case in Supreme Court, and it was 14 years, and in certain cases where the court finds fit, it is given 20 years imprisonment is given. In the recent past, the offences against women are increasing day by day, and the punishment for rape, life imprisonment means 20 years, it was enhanced again throughout the natural life. The life offense against women, I will explain in detail in Indian in IPC. There are so many developments have been made to eradicate the menace of offences against women and children. To that effect, protection of Children from Sexual Offences Act was passed in the year 2012. All these aspects I will explain in detail in the ensuing chapters. So this is why in this case, Bachan Singh was state of Punjab. The court said that, Supreme Court said that death sentence should be awarded in rarest of the rare cases. So now imprisonment for life means 14 years, it may be 20 years. The state government is empowered under section 53 of the Indian Penal Code to reduce the punishment. Suppose certain criminals are maybe due to good behavior or some other reason, certain prisoners are released well in advance, maybe due to their behavior or other reasons. So the state government is given power. According to this new act, Bharatiya Sanhita code, IPC new proposed new enactment, when once state government wants to reduce punishment, it should consult the victim, then only it can reduce the punishment. Some restrictions are made in the ensuing enactment. So these are the position. Imprisonment, dear friends, imprisonment means every offense there will be imprisonment of 6 months, 3 months, 6 months, 1 year, 1 year, 3 years, 5 years, like that, from to life imprisonment. When once in so many offenses, not only imprisonment but also fine will be there, and in some cases only punishment is given, in some cases fine is given, in some cases both fine and punishment will be given. Next, forfeiture of property. Forfeiture of property in criminal law, process to compel the appearance. Some persons may be asked to come to court and give evidence. They will be given summons. If he doesn't come, sometimes arrest warrant may be given to particular witnesses for setting aside the summons. And the summons may be, arrest warrants may be issued not only to the witnesses but also to the accused person. Not only accused but also to the witnesses. Sometimes if the offender, accused person commits crime and absconds, arrest warrant cannot be served, and then proclamation will be there. That is some notification by wall posts or past wall posts in local areas, or if some publication may be made in some newspaper, so and so has committed some offense and has kept absconded. If anybody knows about his whereabouts, they may communicate this matter to so and so police station or so and so. The person who gives information about the presence of the about that person will be given some reward. The type of publication is called proclamation. If proclamation also is not served, if he has any properties, movable or immovable like vehicles or any movable properties, and immovable properties like land and buildings of the accused may be forfeited. This is what is called seizure of the property or forfeiture of the property. This is one kind of punishment awarded. Next one is the fine. Fine means even in fine 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 is, what is the fine, you don't, when drunk and drive cases, the fine is given. Some prostitution cases, fine is given, and so many petty cases, fine is awarded in it. So in serious cases also, not only fine but also punishment is given. In rape cases, in view of so many amended laws, not only the culprit is required to bear all the medical expenses and meet all the expenses till rehabilitation of the victim. These aspects I will explain in detail in chapter of rape and sexual offences against women. These aspects I already covered in previous classes. I will explain in detail. Last one is solitary confinement. Section 73 and 74 of Indian Penal Code deal with solitary confinement. Solitary confinement is certain particular offences, if they are found to be notorious criminals or of most dangerous criminals, they are not in a jail, two or more may be put in a jail depending upon the size of that cell. In some we see in movies also, in same cell two or more persons will be there. In some serious cases, the culprit may be in RR movie, they are put in Ram Charan is put in that solitary confinement. Solitary confinement is how a rat is put in a rat hole. The a convicted person will be there. Solitary punishment is very serious mode of punishment, but the whole period of term should not be given. It is unconstitutional and inhuman. Suppose if this solitary confinement can be given under section 73, the total period of, suppose a person is convicted for 10 years or 15 years, 7 years, the maximum punishment must be solitary confinement. Out of the total term, the maximum 3 months must be, she should be kept in solitary confinement. If the offence he is convicted for 6 months, only maximum is 1 month, he should be put in jail, put in solitary confinement. If the term of punishment is 6 months to 1 year, he should not be put more than 2 months. If the punishment is above 1 year, 2 years, 3 years, 5 years, 10 years, like this, he should not be put in solitary confinement for more than 3 months. So the whole, if it is according to section 74 of the Indian Penal Code, if a person put in solitary confinement for fully year, it is illegal and unconstitutional. This question came for discussion in Charles versus Superintendent of Jail, Tihar. Tihar jail is located in Tihar village near Delhi, dear friends. So these are the cases of these theories and kinds of punishment. This chapter I taught long back. Theories and kinds of punishment, vicarious liability, and jurisdiction. 3 topics I gave lecture long back. But this is an improvement, very good improvement over that. Is what I feel. You also should take. I sincerely tell you. In next class, I wanted to tell you in first what is IPC important topics. I will tell you first 5 topics, next 3 topics, next 2 topics. What are the most important topics? After reading these 10, You may read any more number of topics as per your choice. I will select the best topic and will give you good tips. You those who do not wa, who have not watched my video may watch at least this question, important question. Like that, I will give every subject. I have a lot of work to. I have a strong and serious inclination to upload on subject all subjects because of some other commitment by delivering lectures to Telugu students. The lectures are delayed. So anyway, I will do justice. I sincerely suggest the students to make use of what I have uploaded, and irrespective of year, you may watch all the videos. Spend 1 hour for 2 days and watch all the videos before you leave the college, and then it will be very useful to you in profession as a lawyer, and thereafter as a judge. Thank you very much for your patient hearing.